রিল্যাক্স না এটা হ্যাঁ পারবেন আপনি বারবার পারবেন বারবার স্ক্রিনে শেয়ার করছি দেখেন একটা জিনিস F5 এ দিবেন না হ্যাঁ F5 দিলে যাবে হ্যাঁ মানে F5 দিলে এভাবে দেখাতে হবে এভাবে 1 2 মানে এভাবে নামে বুঝছেন আচ্ছা এই যে স্ক্রিন শেয়ার এটা দিয়ে এখন দেখেন কোনটা which one do you want to share right so we will share this one start screen share
ও আচ্ছা বারবার এখন ওয়ার্ডে গেলে ওটা তো যেতে হবে ওয়ার্ডে যেতে হবে
হ্যাঁ তো বেশি ঝামেলা না
একটা ক্লোজ করে দেন দুইটাই আছে
না এটা থাকতে হবে আপনি সেকেন্ড থেকে ঢুকে if you want to stop it or if you want to change screens then you select here and then you choose which screen you want to go to so এখানে দিয়ে অফ হয়ে যাবে তুমি অফ করে দাও স্ক্রিন শেয়ার এবার অন করেন
আচ্ছা তুমি একটু ওয়ার্ড ওপেন করো ওয়ার্ড ওপেন করো
এটা হ্যাঁ so you're still here even if word is open you get it
right
but যখন আপনি ধরেন যে আমরা এটাতে গেলাম এদিকে নিচে স্লাইডটাতে আসলাম আপনি দেখবেন যে এদিকে নিচে স্লাইড থেকে বুঝছেন না so you're
আচ্ছা এটা ক্লোজ করো উইন্ডোজ গুলো ক্লোজ
না কিছু করতে হবে আর কিছু বন্ধ করে যাবে না there you go you're live
just wait let me check this so if when I share a particular screen
আপনি এখানে স্টপ দিবেন স্টপ দিয়ে আবার শেয়ার স্ক্রিন দিবেন
software দেবো
because এটা নিয়ম কিছু stop
and then এটা ক্লোজ করবো এটা ক্লোজ করবো नहीं होता है
do it বুঝছেন
is it getting shared excellent আচ্ছা
বুঝছেন এখন সিস্টেমটা
আচ্ছা ওরা কি এই পুরোটা দেখতেছে নাকি অপ টু ডেট ওরা করতে পারবে না ছোট লেখা it's full screen there
just পুরো ক্লাস নিয়ে স্টপ ব্রডকাস্ট দিবেন হ্যাঁ তার আগে কিছু স্টপ ব্রডকাস্ট দিবেন ফুল ক্লাস নাও শেষ আর
where is stop broadcast আচ্ছা
okay
therefore use of
stop broad হ্যাঁ স্টপ ব্রডকাস্ট দিলাম কি বললাম কি you would believe আপনি কাজ করেন কি বলে দিতেন
হ্যাঁ
আপনি কোশ্চেনস গুলো এখানে পাবেন ঠিক আছে sir I hope you have Q&A session at the end of the class tell Shobuj you can write your questions here and he will answer to you orally
you can ask your question at any time and although this is kind of getting freaky I will try to cooperate and answer every question cheers okay let's start the class
so then again screen share no good my next class right
welcome to the law of evidence lecture on silence as we know the chapter silence was divided into two parts as we have seen previously firstly we deal with the defendant's right to remain silent and then we look at if he remains silent can you draw inferences from defendant's silence okay we have previously looked at England and Wales common law principles regarding silence so in England and in all the parts of the United Kingdom when someone is charged with a criminal offense and they are being asked questions they can remain silent and traditionally it was held that if they stay silent no one can draw any inference of guilt or any other adverse inferences from their silence however we have also looked previously that the scenario has changed after the 1994 in 1994 the Criminal Justice and Public Order Act came in and it reshaped the concept of silence with regards to defendants when they are being asked questions, whether that be in police station or that be in court. Okay. When we are saying that adverse inference, if I could highlight and if you could see the term adverse inference means the court can draw any negative conclusion. When we're saying court here, you have to understand that we're talking about both the jury and the judge. So in a criminal trial, those who are present in the class, who decides questions of facts? Questions of facts are being decided by the jurors or the members of the jury, and judges decide questions of law. So when deciding facts as to what has happened in the alleged event, be that a murder case, an arson case, or a theft case, the courts are allowed to draw negative conclusion. And they can hold this negative conclusion against the defendant, and they can draw this negative conclusion from defendant's silence when he was asked a question and he decided not to speak about it. The jury or the magistrate would usually draw recent fabrication from defendant's silence. What that means is that when a defendant is staying silent, juries and magistrate would think that the defendant stayed silent because he didn't have an appropriate answer at that point, and then he decided to later on fabricate or change the fact which would favor his case. Okay. Or they can also think that he did not have an adequate explanation for his conduct. So magistrate can have it in their mind that defendant did not have an appropriate answer or an adequate explanation when he was asked, why were you there in the crime scene, right? Defendant say no comment. If it's a solicitor, a no comment interview, or they just kept silent. Juries and magistrates are entitled under CJPOA, if certain circumstances are met, to hold that the defendant is recently trying to fabricate or change the fact substantially. Okay, and that's why, to their own benefit, they remain silent when they're first asked the question. I would invite all of you to look at this part. He, when I'm saying he, it's the defendant. So just read this phrase. He did not believe it would stand up to further investigation. So firstly, during here in this part, we looked that magistrates or juries can think that defendant is trying to recently fabricate. That is the inference that they can draw. Alternatively, they can also draw an inference that defendant remained to stay silent because although he had an answer, that answer was particularly weak. And if, based on that answer, the police or whoever the court asked further questions, then his answers would be destroyed or damaged because it's not a good enough answer. So magistrates can think that defendants remained silent because the defendant did not believe it would stand up to further investigation by the police. As we can see, under the CJPOA 1994, Section 34 to Section 37 created specific situations where, from the defendant's silence, a court can infer adverse inferences. A court can make adverse inferences to be more accurate. If you remember, we have previously tried to justify why the defendant has this right to stay silent. So previously we have seen that it depends on two common law doctrines or presumption. There's this first presumption called the presumption of innocence, and the second presumption is called privilege against self-incrimination. Firstly, it is said that the burden of proof in a criminal trial is on the prosecution, and it is beyond reasonable doubt. So until and unless the prosecution can satisfy the juries that the defendant is guilty beyond reasonable doubt, so there can be no scope or room of doubt in the minds of jury as to defendant's guilt. Until that point has been reached, it would have to be presumed that he is innocent, right? Also, the defendant can stay silent because he has this right or this privilege against self-incrimination. What is self-incrimination? Self-incrimination is incriminating oneself. So if you're asked a question and if you say that answer, that's it. People would think you have done it, right? So since the burden of proof is on the prosecution, he is under no duty to admit even if he has done it. Therefore, he is privileged against self-incrimination or putting his conviction at risk by all his own answers, right? As we know, we also previously saw that the concept of silence came from an outrageous statement made by Lord Mustel. What his lordship wanted to say was that everybody should mind their own business. So if defendant is saying silent, it is none of prosecution's business, and they should allow him to stay silent because it's defendant's business. He can choose whatever he wants to. Now, as you realize, Parliament cannot say something like this. It is often interventionalist judges such as Lord Mustel or Lord Denning who often make such controversial statements. So be careful when you write this in the examination. This cannot be the sole basis of why you say the defendant has to stay silent, because Lord Mustel's explanation that he said everyone should mind their own business. You should attach to it the presumption of innocence, the privilege against self-incrimination, and also your concept with regards to burden and standard of proof, that prosecution has to prove it beyond reasonable doubt. So we're talking about, when you're answering a question, we're talking about just the introduction, how you introduce to the examiner the concept of silence. We also saw that when we mean that the defendant has a right to stay silent, he particularly has three rights. So, right not to answer question generally in police station, right not to be compelled to testify generally in court, and right not to have adverse inferences drawn against him at the trial by the members of the jury, and therefore that is also generally with regards to the court and not the police station. Okay? If I'm allowed to revise a bit. So what is the general rule? That he has the right to stay silent. What does this mean? If he's allowed, no one can make any inference from his silence. That is the general rule, and as in law, they would always have exceptions. Are the exceptions in common law or in statute? The answer to that question is both. We had both common law exceptions, and we also now have statutory exceptions under the Criminal Justice and Public Order Act 1994. The common law exception was laid down in parts. We have done this, or we have covered this extent comprehensively, and we have also covered section 34 comprehensively. So we will not be focusing on revising these parts today again. Today we would move on to Section 35 of the Criminal Justice and Public Order Act. But before that, you must realize that when you're explaining Section 34, it is always, and it is the best choice, to explain the statute with loads and loads of case laws. Maybe not 28, just like here, but have at least 8 to 10 cases explaining what Section 34 meant and the explanatory context of each of the words of Section 34 as laid down in all of these cases, which we also covered previously in the previous classes. So today, as we say, our focus is going to be on Section 35. If I may extend this part, so today we're going to deal with inferences from silence at trial. So we have reached a stage where the investigation has gone on. He has been charged. He has been arrested. He has been charged. Proceedings have been brought against him, and he is at trial stage now. So the defendant has entered the court proceedings. Okay, so juries have been called if it's Crown Court, or there is magistrate if it is a magistrate court, and the defendant is now facing the questions from lawyers and judges. So when you go in a court as a defendant, you would definitely be exposed to questions from the opposition lawyers and also from the judges at particular points. When a defendant is adamant not to speak, the judges can invite him to say at least what he thinks about the questions. Okay, can you, firstly, generally, as a matter of general rule, if he remains silent at the court, can you draw inferences? That is the general rule, right? That general rule is subject to an exception. Where has that exception been laid? The exception has been laid in Section 35 of the Criminal Justice and Public Order Act. So firstly, you need to realize that Section 35 provides inferences can be drawn. So if he is exposed to questions and if he refuses to answer those questions, Section 35 allows inferences to be drawn. Is it favorable inferences or adverse inferences? Adverse inferences. And we have previously looked at what adverse inferences mean. It can firstly mean that he had no answer. Secondly, mean that he's trying to recently fabricate it, change the fact, concoct the fact. And it can also mean that although he had an answer, that was not a good enough answer. And if further questions were being asked, his weakness in the answer would have been exposed. Therefore, he preferred to stay silent and not speak. Okay, so Section 35 allows the drawing of adverse inferences from defendant's silence. Defendant can either choose to not give any evidence or can refuse to answer any questions, right? Now, you have to understand the concept of Section 35, and I'll highlight this with a different color. So first, you need to realize that Section 35 allows inferences to be drawn. When he either fails to give evidence or he refuses to answer any question. Is it in every case that inferences can be drawn? No. If there was a good cause why the defendant chose to not give evidence or to not answer any question, then inferences cannot be drawn, right? So you have to read the section in context carefully. So we're summarizing section 35. We'll look into the details of section 35 in a bit as well, okay? Again, so what kind of inference? Inference would be that defendant had no plausible explanation, or any explanation he does have is too weak to stand up to cross-examination by the prosecution. Let me explain this. So first, the prosecution witness would enter the courtroom and he would be asked questions. That phase is called examination in chief. Once examination chief of the prosecution witness by the prosecution lawyer is finished, the witness stays there. And then the defense lawyer comes in and takes him through a very, I would say, complex theory or complex system of questioning. The purpose of that system of questioning is to undermine the defendant's case. So the defense lawyer, the defense lawyer would come in and ask prosecution witness questions to undermine the case. Okay. Then comes the defense witness. Okay. And the defense witness is being examined in chief by which lawyer? The defense lawyer. So defendant comes in and the defendant's lawyer asks him a question so that the defense version of the theory is being heard by the jury. Okay. Then the defendant stays there, right? And the prosecution lawyer comes in to cross-examine the defendant. The prosecution lawyer would ask series of questions in cross-examination, and the purpose of those questions would be to destroy the defendant's version of the events that he is saying took place. Okay, so everything that has been said, or the major point that the defendant has raised, would be tried, would be undermined by the prosecution lawyer. Okay, so if the prosecution lawyer is asking the defendant questions in the cross-examination, and if he is staying silent, does this not give an advantage to the defendant? Defendant is being asked questions by which lawyer? Prosecution lawyer, and he's remaining silent. So can the prosecution lawyer proceed with his theory? Because if you don't answer a question, can I ask you the next question? These are like coherent questions. So like for a theory, there are like 20 questions. So each 20 question is about a single fact. Okay, let's take for example that you saw someone. Okay, or let's make it easy. Let's take for example the defense of self-defense. One of the elements of self-defense is that the force that you used was reasonable. So if someone comes to attack you, you can attack him back, but with a force that is reasonable. Prosecution is trying to establish the fact that defendant did not act in self-defense, but rather he attacked first. Okay, so it was an intentional attack carried out in a planned, cold-blooded manner. That is what the prosecution is trying to establish. So what would the prosecution say? The prosecution say, let's say for example, the force you used was of such significant level that this cannot be self-defense. You used excessive force, by which they're trying to signify that you did not act in self-defense. How would the prosecution prove it? The prosecution would try to prove that the defendant was drunk. Since he was drunk, he could not think of, or he could not estimate the force that needed to be used, and he used excessive force. So if you use excessive force in a self-defense, would you get the self-defense? No. So one of the significant theories in prosecution theory was that he was drunk and therefore he could not contemplate the amount of force that needed to be used. Therefore, he used excessive force and therefore he did not act in self-defense. So you see, the fact that the prosecution is trying to establish that there was no self-defense is dependent on some previous facts. That excessive force was used, 1, 2, that he was drunk, right? So if now prosecution lawyer asks a simple question, how many pints or how many glasses of beer did you drink that day? He refuses to answer, right? How long have you been drinking? He refuses to answer. From which angle did you attack? He refuses to answer. Can they establish the fact that he did not act in self-defense? Can the prosecution lawyer establish it? No, because defendant is consistently refusing to answer, and therefore they cannot prove their theory, the prosecution. Okay? So, look at this part again. The inferences that would be that any explanation the defendant does have is too weak to stand up to cross-examination. Okay? And therefore, he is intentionally staying silent. Since he cannot survive the cross-examination, the entire cross-examination, from the beginning, he's refusing to answer and he's staying silent. Why? Because if the cross-examination is carried out, his lies and his weakness in his case would be exposed. Okay? Therefore, juries are entitled to draw this inference that he remained silent. Why? Because he thought he could not survive the cross-examination. Right? Good. Was it too difficult? No. Now we're going to move into the actual details of section 35. Where is the place? Where is the place that he's staying silent in section 35? At trial. That means he's in the court, right? When a defendant comes in or when any witness comes in, he's first sworn. Do you understand the concept of being sworn? So there is an oath that has been made that whatever he would be speaking, he'd be speaking truth and nothing but the truth. That is the concept of being sworn. Okay, it's often done in Christian community by the oath with regards to the testament. Okay, so either the defendant is refusing to be sworn, or having sworn, he's refusing to answer any particular question. We are studying when section 35 can be applied. So section 35 can be applied in the court at 2 stages, or with regards to 2 particular incidents. One is that he's refusing to be sworn. Second is that although he has sworn, he's now refusing to answer the particular questions that are thrown at him. Okay? Very important when you deal with any provisions of silence is the issue of caution. So we know law, the defendant in England or an alleged criminal in England is supposed not to know law, right? So what can you think? Let's be silent. If I talk, I might be exposed. So you have to caution him. Look, if you stay silent, later on, if you try to rely on it in the trial, we can make adverse inferences. So the issue of caution is very important. So the accused must have been made aware what that the stage of proceedings at which he or she is in has been reached, and if they do not give evidence, a court or jury may draw such inferences as appear proper. Okay, let me break it down. So the issue of caution is practically given in this way. It would be saying that defendant, you've been arrested, you've been charged, evidence have been drawn against you, and now it's time you face the trial. So we have reached a phase of the proceedings where you're expected to say what you want to say, or you're expected to give evidence. And if you choose not to do so, the court, i.e. the judges, the magistrates, or the jury may draw inferences. So you're expected to answer, and if you're not answering, this is a phase where we are cautioning you that we might be drawing inferences. So before even section 35 applies, you have to realize that the issue of caution is very important, and the defendant must have been cautioned. Otherwise, you cannot draw inferences under section 35. So if we revise, general rule is that he can remain silent. It has statutory exceptions. What is the statute? Criminal Justice and Public Order Act. Criminal Justice and Public Order Act allows drawing of inferences at particular situation. One of the situation is where you are staying silent at the court. That situation is dealt with by section 35. Section 35 allows drawing of inferences by 1, the court, 2, the judges or jury. And section 34 can be activated, section 35, pardon, can be activated if you either refuse to get sworn, or having been sworn, you now are refusing to answer questions. But before activation of section 35, the defendant must be cautioned. What would be the language of caution? The language of caution is that you have reached a phase where you're expected to answer, and if you do not answer, the court is entitled to make inferences, adverse inferences. Okay, so those of you who are present in class can take notes, but I would be giving this in the photocopy section today in any case, and those of you who are watching from home can collect it from the photocopy section. Okay? There are exceptional situations where section 35 would not apply. So before going to understand or study section 35 in details, let us just clarify out the areas where section 35 would not be activated and they cannot make adverse inferences against particular class or group of defendants who fall within the exceptional category of section 35. First category is defendants under the age of 14. Well, the concept is, if he is under 14, how can you expect him to answer in first place? So he would be someone who is young, who would be startled, and whom you should not be in first place expecting to answer even. So if he stays silent, you cannot activate section 35. So section 35 allows inferences to be drawn. And if you're If section 35 is not being activated, you cannot draw inferences. The general rule prevails, right? Unless if you fall within the common law exception laid down by R versus Parks, R and Parks. If the defendant's guilt is not in issue, then you also cannot make inferences under section 35. Okay. What do we mean the defendant's guilt is not in issue? This is something that you just read and remember. You do not stress upon it so much because these are procedural issues and you would be studying these kind of hearings in the court when you go to the BPTC. Okay, there are some hearings which are preliminary to the trial. Okay, so before the actual trial starts, which would be the actual hearing, there's a pre-trial hearing. Okay, in those pre-trial hearing, the defendant's guilt is not an issue. The defendant's guilt is an issue in the actual hearing where the conviction would be placed upon him. Often, the pre-trial hearings are management hearings, okay? It's a case management hearing. Once the case starts, it is in the best interest of both the court and the parties that it does not get lingered too much. So the courts would try to ensure that all the evidences and everything are collected before you head for the actual trial. So in those case management trial, defendant is not being tried. It is the collection of the material evidence. So there you're not deciding defendant's guilt. Okay. At that stage, if he stays silent, his guilt is not an issue, and therefore you cannot draw inferences as to his guilt. Clear? Also, there is some trial before the actual trial, which is called the plea trial. You do not need to learn the technical terms. Just remember the concept, okay? Plea. So defendant is asked, do you plead guilty or do you plead not guilty? And he stays silent. It does not mean he is guilty. You cannot draw inference because his guilt is not an issue in those pre-trials, right? The third category of defendant would be those who are suffering from either a physical or mental condition. You have to realize that it's a two-limb test. So firstly, it's physical or mental, but that is not the only test. You'd also have to satisfy that it was undesirable for him or her to give evidence. So firstly, there has to be a physical condition or a mental condition. Then that physical or mental condition must make it undesirable for the accused to give evidence. This is where the defendants are vulnerable. They're weak in heart or weak in mind, and they would not be able to answer questions, or they would not be able to survive the pressure of cross-examination. So if you put him at cross-examination, his physical or mental fitness or strength would be at risk. And therefore, since it would be risky for the court to assume inferences from it or to subject him to cross-examination, in those kind of cross-examination, if the defendant stays silent, you cannot make adverse inferences. The final category is where there is a good cause for refusal. So let us summarize. Section 35 does not apply, and therefore you cannot draw inferences if 1, defendant is under 14, 2, defendant's guilt is not an issue, 3, there's mental or physical illness which makes it undesirable for him to give evidence, and finally there is a good cause for the defendant not to speak. So there's a good cause for silence. What could be that good cause? Are you familiar with the concept of legal professional privilege or legal privilege? No. Let me explain. When you go to a lawyer, would you not be truthful, your own lawyer? Would you not be truthful as to your case, right? You would be truthful. And your lawyer would try to definitely defend you if you are a defendant, okay? There will be lots of communication between you and your lawyer as to the actual facts. There will be lots of communication, confidential communication between you and your lawyer. If the court starts asking question, what did you say to your lawyer? Are you expected to answer that? It's your lawyer. Since it's your lawyer, you could trust him with lots of information which you might not be able to comfortably say in the court. So the courts are not allowed to ask question, what did you speak with your lawyer? Okay, those are privileged conversation, confidential conversation, and this can be a good cause for staying silent. Or also, if your solicitor has stayed, say no comment, can it also be a good cause? Yes. So the solicitor has said, do not speak about it when you've been asked questions. We'd look at it. So you genuinely and honestly believed in the solicitor's comment, and depending upon him, you say, I'm not going to answer anything. So on that silence, the section 35 would not be activated. Because why? Because there was a good cause. So if we go and read the summary of section 35 again, remember we say CJPOA 1994, section 35 provides inferences can be drawn. So you are allowed when either he's failing to give evidence, or he's refusing to answer, or he's not assisting the court in getting sworn, right? But there cannot be a good cause. So if there is a good cause, you can stay silent. One of the most important criteria of section 35 is laid down in the test that the accused must be aware that a stage has been reached where he is expected to answer. So we're talking about the issue of caution, the issue of caution. Before you can say, from your silence will make adverse inferences, you must first caution him. Do not stay silent. We have reached a stage in the proceedings where you're expected to answer, and you now have to answer. If you do not answer, we might be able to make adverse inferences which might appear proper to us. So it's just an elaboration. If he chooses not to give evidence, or having sworn without good cause refuses to answer any question, it would be permissible for the court or the jury to draw inferences as appear proper from his failure to give evidence or his refusal without good cause to answer any question. When you write in examination, if you can first just memorize bits and pieces of statute which are the actual test, and then can replicate them in your answer, you'd be getting much more mark than who's just explaining the statute simply. So it is always, examiners in law always expect you answer according to the parliamentary language. So this is the test that has been laid down for the test of caution, that the accused must be aware that he has been made aware that a stage has been reached where he's expected to answer, and if he does not answer, inferences would be drawn against him. That is the simple one-line explanation of all this subsection 2. But obviously, if you can write this test, you'll be getting much more marks. Now, When CJPOA 1994 first came in, academics thought this is a section of compellability. So you are trying to compel the defendant to answer. It was later clarified that no, section 34 is not saying that you have to answer. We're reading this bit. So this section does not render accused compellable. By application of section 35, you cannot say that you have to answer. You just caution him. If you do not answer, we'll make adverse inferences. This does not mean that you're saying you have to answer. Even after the caution, he refuses to answer. He's not contempting the court. Do you understand the concept of contempt of court? Let me explain. So contempt of court is a scenario where the court says you have to do something and you do not do it. You're saying that you have contempted the court, or you've made the contempt of the court. That means you have made the highest disregard or disobedience to the court. And contempt of courts are often punishable. So is section 35 creating a contempt scenario? No. Section 35 is not creating a contempt or a compellability scenario. It's just saying, look, you're expected to answer. If you don't answer, we'll make adverse inferences. They are not saying if you do not answer, you're in contempt of the court and we'll criminally punish you. Do you get my point? So it's not so strict as academics and writers thought that it was. So when section 35 first came in, academics thought this is a section which is compelling the defendant to answer. No, it's not compelling. They also thought that it is compelling and it is making the defendant in a contempt of court if they're not answering. So they're disobeying the court. No, it's not like that. He can still stay silent, but he's cautioned that if you stay silent, we'll make adverse inferences. That's the effect of section 35. So remember, when we studied the exceptions of the application of section 35, we studied the third limb was that if the defendants are suffering from physical or mental condition, which was making it undesirable for them to answer a question, you cannot draw inferences under section 35. That's a plain and simple statute, but you need to explain it with relevant case laws to get the highest or the most expected marks, as you say. So we're going to explore this part, mental condition of the accused, which makes it undesirable for him or her to give evidence. With regards to this concept, is the court willing? That's the first question. Answer to the question is no, they're not willing. Why? Because courts have interpreted this provision narrowly. So they're not going for a wider interpretation. They're reluctant. They are more reluctant to excuse defendants who are trying to claim that they're suffering from mental or physical condition. So what can be physical condition? Can fever be a physical condition? Think. Can it be? If courts were willing, they would say yes, it can be, right? Does it need to be a serious physical condition, such as epilepsy or something like that? We will study these with case laws. So first concept is courts are reluctant in interpreting this provision. They are going or taking rather narrower approach. So they're less reluctant to apply this section. If this provision applies, can you make inferences? If a defendant is suffering from mental or physical illness? No. So if the court is saying that we're taking a narrow approach, they're basically meaning we really test your physical or mental illness, whether you should be excused from answering, okay, or whether you can be excused as to your refusal to answer the question that had been put to you at a trial. You have to understand, can anybody in the class say why they are taking a narrow approach? It's a difficult question. Okay, I'll answer. Think, it's a trial phase now. That's the last phase. After that is conviction and then punishment, right? And then serving that punishment. So at a trial, you have reached the last phase of a criminal proceeding. If now you don't answer, when are you going to answer? That's the concept. So the court is trying to encourage the defendants to say whatever is in their mind. And therefore, they're taking this narrow approach so that they are not excusing the defendants regularly on the mental or physical illness basis. Okay? In the case of on the application of DPP and Kavanagh-Sean, it's a 2005 case. The administrative court said that it is not enough that the defendant should be suffering from physical or mental condition. The condition must be such as to make it undesirable for him to give evidence. So there is a causal link. There is a causal link between the mental or physical illness and the fact that it is making it undesirable. So just because there is a mental or physical illness does not mean you're excused. It would also have to be undesirable for him to answer. That's a very strict approach adopted in Kavanagh. Is Kavanagh a good law? Yes. Why? It has been followed. When? Recently, in 2009. So in your copy, on your answer script, you write, okay, section 35 can be applied. First, you also discuss the caution bit, that the judges would have to caution him. Then you say there are exceptions, and often this appears in the exam. So we're elaborating this. Often there will be some physical illness or some mental frailty or weakness, as a result of which the defendant refuses to answer, and the solicitors try to take advantage of it by saying that since you're ill, do not answer, just get away with it. Okay. Once you write that, you also write that although such condition does not activate section 35, that means you're excused from the application of section 35, still the judges would really test your mental or physical illness and or the fact that whether that is making it undesirable for him to give evidence. What is the common law relevance or the case law? It's Kavanagh. Is Kavanagh good law? Yes, because R versus Enzer or R and Enzer has again confirmed. Can the defendant say I'm distressed and therefore it is undesirable? Can the defendant say I'm distressed and therefore it is undesirable for me to give answers? Says who? R and Branchflower. It's another 2009 case, and it's an important case since it's a Court of Appeal decision. Court emphasized that defendant's distress, just because of the fact that defendant is not distressed by facing the trial, he's trying to refuse to give answers. They say defendant distress cannot be a reason for an exception to section 35 of apply. Now, you're a defendant. Would you not be distressed? You'd definitely be distressed. There would possibly be no defendant on earth that would not be distressed, since he is a defendant, right? He can go to jail. He can be hanged, not hanged in England, but yeah, he can be facing a life sentence, right? His family and his job and his every life would be jeopardized. So definitely he would be distressed. Defendant cannot say I'm distressed and therefore I'm not going to speak. Even if you're distressed, which you're expected to be because you're a defendant, you have to speak. Okay? So distress cannot be a ground for mental or physical condition, mental condition. So your distress doesn't count as mental condition. Fine? As you realize, we have focused this discussion. There have been some previous cases as well since CJPOA came in almost like 20 years ago, but we're focusing on recent cases only. So 2005, 2009, 2009, and later on we see lots of other cases which are like after 2000. So these are recent cases, and with regards to your other subjects as well, do not just write the conventional cases. So if you're trying to aim for 60s and 70s, you'd rather be writing cases from the last 10 years, because common law after England with regards to criminal law, evidence, contract, whatever it is, has been significantly changing after the Human Rights Act 1998. So if you're writing cases from 1960s, that's European Union or whatever, they would make less sense, because EU law and HRA in terms of international politics is now creating utmost pressure in the judiciaries, or let's say the politicians of England. After the enactment of HRA 98 and the European Communities Act 1972, the judiciaries have been empowered with lots of interventionist tactics. If you remember from your first year study, section 2, 3, 4, 5, 6 creates lots of pressure on the parliament even to legislate in a manner that is compatible with the European Convention of Human Rights. So if you are not complying with the European Convention, the judges have now this power under HRA to intervene. They can stop you, they can make you comply. Okay, if that is the case, then after 2000, which is the year that HRA actually came into play, the cases are now being differently decided. So cases which would have been having a different result are having now a total different result just because of the enactment of the HRA. So when you answer with regards to any other subjects, evidence and crime particularly, always try to mention cases from the last 10 years, because they reflect the current law. And the examiners always appreciate if you write current law rather than those key fact and nutshell cases, which are the like 1960s and 1970s. Okay, so even if you have to write landmark cases, make sure that you are also referring to cases which have recent implications. This point, we're dealing with this point now. Are all evidence of the same probative worth? So would every question be equally important? So there'll be some questions that are being asked to the defendant which are important, and therefore the answers are important. And there'll be some questions which, if the defendant doesn't answer, doesn't change the case significantly, and therefore the defendant may refuse to answer, and the judges may take an easier or less strict approach. So in Tabak, a judge is entitled to take account. It will say that a judge is entitled to take account the potential significance of defendant's evidence. So it depends on the probative worth, the significance, the importance of the evidence. If you are remaining silent at a point where there is a significant evidence that is being expected from you, significant answer is expected from you, then they can make inferences. The less its significance, like this, the less it's significant, the less severe the physical or mental condition would have to be to make it undesirable for him to give evidence. So if it's a less significant answer, if it's a less significant evidence, your mental or physical condition does not have to be that severe. You can say, okay, I'm having a headache, let's not answer it. And judges would not say, since you have a headache, we'll make adverse inferences from it because you refuse to answer a question. It's not any question that the judges would look at. It's the important question. So if you're trying to stay silent on a very important part, on a very important question, at that point, the judges would intervene and would say, look, son, your mental condition, as we think, is not so serious, and this is a significant evidence that we need to decide the case, and therefore you have to answer, right? Then probably you'd have to say, I'm dying. It's almost like a death or life scenario where you'd be excused from refusing to answer. Okay, so your refusal to answer based on mental condition, making it undesirable for you to answer would have to be significant if the evidence that you're trying to hide or not reveal through your answer is significant. So it's a test of proportionality. So the more important an evidence is, the stronger, or the, let's say, the weaker would have to be your mental condition to answer the question. Look, what do we mean when we say it is undesirable for him to testify? It means that defendant is going through a physical or mental health problem, and that would be adversely affected if he testifies. Let's say a defendant who's very weak in heart has gone through 3 bypass surgery. So he's very weak in heart. So he has heart diseases. He cannot handle pressure. He cannot take pressure. And if you have someone in the court, in the prosecution lawyer panel, who's like those Hollywood lawyers who would make you cry in the court, then the defendant would die answering, right? At that stage, is it desirable for him to answer? He has a physical condition, a very weak heart, right? Very weak heart. Therefore, he has heart diseases, and that may be aggravated or affected if he is subjected to pressure. And cross-examination, trust me, I believe you, is immense pressure, is intense pressure. When you're being cross-examined, you're being put through hell. And most people cannot survive through this hell. And people with weak heart, they would die, right? At that stage, it is at his health or mental fitness would be adversely affected. And therefore, it would be undesirable for him to testify. If it is undesirable for him to testify, should he testify? If it is undesirable for the defendant to testify, should he? No. And if it is undesirable, can you make adverse inferences? No. Because should he just die answering your question? No. He should be allowed to stay silent. So again, just a checkpoint. We were studying section 35. Section 35, does it allow making of inferences? Check this part. Yes. Okay. But before section 35 applies, you need to caution the defendant. What is the caution? This is a stage where you answer. If you don't answer, we make inferences. As simple as that. And section 35 is not always activated. There are special cases where you cannot apply section 35. One of those scenarios which often appear in the exam is that the defendant is suffering from physical or mental illness or condition, which is making it undesirable for him to testify. That means he doesn't want to testify. Why? Because his health or his mental fitness can be severely affected if he chooses to do so, right? And we've checked that with regards to this principle, the test that is applied is very narrow test. So the judiciaries are reluctant to allow defendant to rely on the mental condition to avoid questions. Okay? So Kavanagh is a good law since it has been again reaffirmed in the 2009 by R.N. Ensert. Branch-Flower also says minor mental problems such as defendant's reasons distress cannot be a reason by which you would be able to escape the section 35 application, right? And we're now considering when does it make it undesirable for him to testify? When his physical or mental health would be adversely affected. Okay, check this point. The test is not a test of reliability. So if, as a defense lawyer, you're trying to put an argument that I have a mental condition, and because of that weak mental condition, the answers that I would be giving would be unreliable, or would not be true, or would not be accurate, because If you ask me strong, strict questions, I get nervous, and therefore I start to give answers which are not really what actually happened in the case. Okay? So there are some weak, low IQ characters or personalities. If you subject them to pressure, they crumble under the pressure and they try to just escape that situation by saying whatever has been said. So even if you're charged with murder, and even if you have not murdered, just because in an open court you are being asked or you've been ridiculed, you're being cross-examined, you may try to escape that cross-examination by saying, okay, I've murdered, and therefore I'm going away. Okay? So would your answers be reliable? Would your answers be accurate? Why? Because your mental fitness is a very low level, right? But judges are again very strict. They're saying, no, you cannot escape Section 35 application by saying that. Since you have a weak mind or a mind of low IQ, you'd be able to not give accurate answer, and therefore you should be exempted from application of Section 35. Judges are saying your mental or physical health would have to be adversely affected. It is not a test of reliability of whether your answers would be reliable. So even if your answers are unreliable, you're still mentally fit, because it is not undesirable for you to testify. Why? Because your mental health would not be adversely affected. Clear? This was decided in R versus friend. Not so friendly approach by the judges, though. Let's just scroll up and check. So remember, in Section 35, we say, yes, you are allowed to make adverse inferences, but if there is a good cause, you cannot make adverse inferences. Who is this you? The court or the jury. Okay. So the jury or the court can draw inference, but if the defendant stays silent because of a good reason, they cannot draw inferences. We're now going to look at a couple of cases, or maybe just one, with regards to what can be a good cause. Look, accused has taken stand. What does it mean? He is standing at the trial, but he is refusing to answer. Why? Because he has a good cause. This means that an inferences may not be drawn where he is entitled to claim legal professional privilege. What is again legal professional privilege? It's the confidential communication of the defendant with the defense lawyer. So the defendant would be saying or confessing even a lots of things to the defense lawyer, so that the defense lawyer can draft a better defense or draft a better case theory. If now the court starts asking question, what did you say to your lawyer last night, or what did you just what did you just say with your lawyer when you were entering the court? You'd say nothing. Why? Because that is privileged or confidential information. What I spoke with my lawyer, what my lawyer said to me, what I said to lawyer, and the communication, the entire communication, the papers, you are not allowed to look at it, because I am not here to ruin my case. The burden of proof is on the prosecution. Since the burden of proof is on the prosecution, why should I answer? I can stay silent. And am I staying silent for a bad cause? But it's a good cause, because it's a communication between me and my lawyer. Why on earth would I say it to you, right? Why would I self-incriminate myself? Remember the concept that the right to silence comes from two principles: presumption of innocence and privilege against self-incrimination. So if you say, or if you end up saying information that you share with your lawyer, would you not end up self-incriminating yourself? Therefore, you're not expected to self-incriminate yourself, and that is a good cause. Excellent. Can the judge exclude or prevent the drawing of an inference under section 35? The answer to the question is yes. Okay, first check. When is section 35 applied? 1. The defendant is in court. 2. He is refusing to get sworn. 3. Although he is getting sworn, he is refusing to answer. 4. He has been cautioned. 5. He does not fall within one of the exceptions. So therefore, section 35 should apply and the judge or the jury may draw inference. So even if all those conditions are satisfied and therefore the application of section 35 is imminent, can the trial judge say, okay, this is a case where we do not draw inference, although the conditions of section 35 are met? This was famously enunciated in the case of R versus Kwan, and you have to write this in the exam. So R versus Kwan direction, let's go and check what it says. Firstly, check that, but it ought only to be exercised if there is an evidential test for doing so or in exceptional circumstances. So generally, if the conditions of section 35 are met, the judge would not exercise this exclusionary discretion and section 35 should apply. However, in exceptional situations, it is the judge's discretion to apply this exclusionary discretion, whether to exclude or prevent the drawing of an inference. It has been enunciated in the case of R and Cohen in 1996. Cohen is a test of 5 steps. So judges always look for Cohen direction. We take a break for the Ajahn. Okay, let's just do this. Students being online, you can leave your questions if there are any. We're taking a break from the Ajahn and we'll resume in probably 5 minutes. You can leave your questions now if you want to. I'll answer them when I return or at the end of the lecture.
আমি না কিছুই করি না আমি ফার্স্টে খুব কনফিডেন্স ছিলাম যে শেষ 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 মানে কি আমার জীবনে তো আমি তো তারপরে ওই যে একটা ফাংশনাল ডিপেন্ডেন্স গিল্ট ইজ নট এন ইস্যু এটা বলতে কি এটা বুঝাচ্ছে যে মানে তখন তো হচ্ছে ট্রায়ালটা মেইন ট্রায়াল হয় না এই জন্য ডিপেন্ডেন্ট গিল্টটা তখন ইস্যু করা হয় না এই জিনিসটাকে বুঝাচ্ছে না অন্য কিছু ডিপেন্ডেন্ট গিল্ট
আচ্ছা 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 মানে আপনার কোশ্চেনটা হচ্ছে
হ্যাঁ
প্রি ট্রায়ালে যখন কোয়েশ্চেন করা হচ্ছে তখন ডিফেন্ডেন্স গিল্ট ইজ নট এন ইস্যু এইজন্য সাইলেন্স থেকে আপনি কিভাবে ইনফারেন্স করবেন গিল্ট that is the concept হ্যাঁ since তখন তো ও কি গিলটি নাকি নট গিলটি ওই কোয়েশ্চেনটাই অ্যারাইজ করে since ওই কোয়েশ্চেনটা যদি অ্যারাইজ না করে থাকে
তাহলে তো মানে সাইলেন্স থেকে আমি ইনফারেন্স ড্র করতে পারবো
এক্স্যাক্টলি so let's start okay we were looking at the case of R versus co1 or R and co1 so we're almost at the end of the section 35 section of the chapter silence. In R versus co1 it was said that although section 35 has been satisfied, so all the criteria have been satisfied and therefore section 35 should apply, and if section 35 should apply, the judges or the juries should be allowed to make inferences. Still the trial judge, this is the power of the trial judge or the choice of the trial judge, discretion. Since still the trial judge can do what? Prevent the drawing of inference even after the conditions of section 35 are met, but they would exercise this discretion carefully and only in exceptional situations as laid down in R and co1. Co1 has been developed or designed in 5 steps and says that a court must take, prior to section 35 adverse inference being drawn, what should the judge do? The judge must tell the jury that the burden of proof remains on the prosecution. Again, What are we studying? We're studying silence. That defendant has a right to stay silent. That is a general rule, but it has exceptions. One of the exceptions is created by the statute, which is Criminal Justice and Public Order Act. And there is section 35 in CJPOA, which says that in court, if you stay silent, we can make adverse inferences. Allowed. Section 35 is allowing that. But even if section 35 were to be applied, prior to its application, judge must ensure 5 steps. Step number 1, as laid down in R and Code. Judge would say to the jury that although you are taking inferences from his silence, it is always the prosecution who are to prove the case. Okay? If the prosecution are to prove the case, you cannot say that just because defendant is silent, he's guilty. Who is to prove guilt? The prosecution is to prove guilt. On what standard? On beyond reasonable doubt. If you're saying someone is guilty based on silence, can you be free of doubts? So you asked a question to the defendant. Did you not kill? You killed, didn't you? And he stayed silent. And you're saying you're guilty. Think of it. Can you be free of doubt? Inferring guilt from silence should be full of doubt. It's doubtful. What is his answer? You do not know. Since you do not know his answer, it is extremely doubtful to draw any inference of guilt or whatever from his silence. So Cohen correctly said, even if you are drawing inferences from the defendant's silence, the judge is saying this to the jury, you means jury, okay? You be particularly careful not to convict him on the silence. Why? Because it is the prosecution who is to prove the case. It is not the defendant's answering or not answering that should matter. What should matter is whether prosecution has successfully established its case. And think carefully, do you think there is a high chance? Do you think there is a high risk? Or do you think there is a strong chance that the defendant is guilty? Even if there is strong chance, is it satisfied beyond reasonable doubt? Chance is not satisfaction beyond reasonable doubt. Even a 90% case is not satisfaction beyond reasonable doubt. Juries are directed so that they feel one word. What? So that they're sure. S-U-R-E. You have to be sure before you convict. And you cannot be sure based on someone's silence. That is the first limb of the R and Cohen test. Second, they must say, they means the judge, the judges must say to the jury that the defendant has the right to remain silent. Well, this right is historic. It's been there in the common law of England and Wales forever. The defendant has the right to stay silent. Why is that so? Because since prosecution are to prove, I would just go there and mum my mouth and just stay silent. If the prosecution has strong enough evidence, they will be able to prove it in any case. Me answering or does me in a not answering should not significantly affect the prosecution case if they're really capable of proving it beyond reasonable doubt. So in common law, I had the right to stay silent, and section 35 is an exception. So generally, general rules are be followed, right? In exceptional situation, the exception should apply. So it's just reminding the jury of the fact that general rule is he can stay silent. There is nothing wrong in it, okay? Third, silence cannot be the sole basis of guilt. Silence cannot be the sole basis of guilt. Why? Link it with the previous principle. Because defendant has a right to stay silent. And from his silence, you cannot say he's guilty. It is still the prosecution who has to prove it beyond reasonable doubt. Okay. We're studying again. R and Cohen is saying even after section 35 has applied, the judges remind the jury of certain facts. So the inference that you're drawing from section 35, you means jury. inference that the juries are making from Section 35 application should be limited. It should not on its own mean defendant's guilt. So it can be one of the supporting evidence. If you're convinced beyond 90% by prosecution other evidence, you can take 10% inference from the silence, but silence cannot be the sole reason for saying that the defendant is guilty or not guilty. Okay? Okay, are you familiar with this principle of case to answer? Do you know what it is? Okay, let's explain. Defendant is only expected to answer when there is a case to answer, right? So if there is no case, why would I answer? Okay? Out of the blue, the prosecution comes and says, you burnt the house. You burnt the house. Who has seen it? No one. Is there any evidence? No. Do you have to answer the question? Do you have a case to answer it? If you were at that place on that night, do you have a case to answer now? Maybe because you were at that place, right? Even if you're not at that place, if it's your place, right? It's your house. Do you have a case to answer? Maybe yes, because there's an insurance claim that you might be able. So there must be some sort of link. There must be some sort of link with the defendant of what the prosecution is alleging. Out of the blue allegation with no evidence, weak evidence, fragile evidence, they do not have a case to answer. And if you do not have a case to answer, you shall not answer. And therefore you have absolutely every right to remain silent. So therefore the jury must be satisfied that the prosecution have established a case to answer. Okay, where is this establishment? We're talking about establishment in the court. What would generally happen in the court proceeding is that prosecution would open the case. Okay, so when they open the case, they are entitled to detail or entitled to enumerate what they are actually trying to establish. Okay, they must have empirical or evidential basis of what they're saying. So they can say, look, this is the CCTV picture that shows the defendant was there. Look, here is someone who's testifying that the partner had a quarrel, therefore they might be able to burn the house. Look, here is a claim that he has an insurance claim just registered 1 month ago. Therefore, to claim the insurance and in hatred with his friend, he burned the house, and it can be evidence from his picture in the place which shows he was there. Okay, so there is a case to answer now because prosecution has established a case. If the prosecution say he burned the house and could not say it why, then you do not have a case to answer. So if the prosecution have established a case to answer, then Section 35 could apply. If they have not, Section 35 inferences should not be drawn. The jury may not believe witnesses whose evidence the judge thought raised a prima facie case. A prima facie case is establishment or adducing sufficient evidence. Okay, so if sufficient evidence has been adduced, then there is a case to answer, and then therefore the defendant is expected to answer, and therefore he should answer. And if he does not answer, and if the Section 35 conditions are all met, the juries are entitled to draw inference. If there was not a case to answer, he is not expected to answer, and therefore he can remain silent. Even if Section 35 sections were applied, the judge can exclude or limit the drawing of that inference from application of Section 35. The fifth limb is very important. So as you see, Cohen re-enumerated the common law test that always existed in R versus Sparks. Remember, when you are being made an allegation and where you reasonably expected to answer and you do not answer, it is held that you did not answer. Why? Because you had no answer, or an answer that would not stand up to investigation, right? So fifth limb says, if having considered the defense case, so it is after the defense has submitted their evidence to examination in chief and also have opened the case saying what their version of fact is. After establishment of the defense case and after having considered the defense case, the jury concludes that silence can only sensibly be attributed to the defendant having no answer or none that would stand up to cross-examination. They may only draw an inference then. No. It says when the defendant has submitted his case, so the jury has heard both versions of the events, prosecution's version of the theory and defense's version of the theory, and after hearing those both theories and both evidences, the juries think this guy, this defendant is not answering. Why? Because he has no answer. Prosecution case is so strong and the defense is so weak that he has no answer, or the defense theory is so weak that even if he has answers, those answers would not stand up to cross-examination. So when he would be examined by the prosecution lawyer would definitely try to undermine the defense case. Prosecution would try to blow away the defense theory, and when he would be cross-examined, he would not be able to answer questions, legitimate questions, which the prosecution would put forward in cross-examination. Therefore, to avoid that cross-examination, he stayed silent. And in those cases, are you entitled to draw inferences? Yes. Okay. Because you're trying to avoid cross-examination by staying silent. So cross-examination is a technical process. So you build up. Your answer number 10 would determine what is my question number 20. Or your answer number 5 would determine what would be my question number 10. So if you're not giving me answer number 1, 2, 3, 4, 5, I can't ask you the 6, 7, 8, 9, 10th question, right? So to avoid that cross-examination, because your answers would not survive the cross-examination, you're being silent. So in that case, court, judges, juries are allowed to draw inferences. What sort of inferences? Adverse inferences. Are they necessarily of guilt always? No. Can be of, again, just go back and review. Adverse inferences could be any inferences such as negative conclusion, i.e. recent fabrication. You didn't answer because you're now trying to change your theory, recent fabrication. Or if it was investigated by the prosecution bodies, police, courts, it would not stand up. So you do not survive because you're trying to lie. You can't lie 100 times. You can't just fabricate 1 or 2 lies. So you chose not to lie. Why? Because you thought the later lies would be caught. So you remain silent. So the negative questions never arise, which you have to answer later. Okay? Okay, after Cohen, this case is very important. Condron, which says failure to direct the jury with regards to what? The Cohen direction, the 5-limb Cohen direction. If you fail to give the 5-limb Cohen direction to the jury, there might be a violation of right to fair trial under Article 6 of the European Convention of Human Rights. And as a result, your conviction may later be quashed. Okay, so if the jury thinks, okay, this guy doesn't have any answer, you still give the Cohen direction. You remind them what the general rule is, what the burden of proof, what the standard of proof, what the general rule with regards to silence is, or what the rules are. So if even after considering these rules, the juries find or take inferences, let them. That's their choice. But as a judge, you have this duty to direct the jury as to the proper finding of the inference at proper circumstance only. And if you fail to give that direction, then there might be. It's not saying there will be. It may result. Okay, it may result in a violation of Article 6. And Article 6 after 1998 has been considered to be one of the most strongest articles, breach of which might result in quashment of conviction, which means even though you're convicted, that conviction would be overturned. Now answer me this. When someone is convicted, is he convicted solely on the basis of silence? No. There are other evidences which are considered when someone is convicted. Okay? So, excuse me. So just because you didn't give koan direction, your entire conviction is at risk. And entire conviction means selection of the jury, process of the trial. It's like 200 days at risk, because a trial goes on and on and on forever, and the evidences do not turn up. They have to reschedule the trial stages and dates, and the trial is a lengthy process. And after securing the conviction, if you risk the conviction because of quashment, right, it makes no sense. So give the koan direction, as simple as that, right? For not giving koan direction, what can happen? There can be violation of human right. And if there is a violation of human right, your entire conviction can be quashed, even though silence was just a mere issue, even though there are lots of other evidences and expenses, most importantly, borne by the police and the detective branches and everything, right? So make your conviction secure. Just give the koan direction. Juries are, in any case, they're not allowed to draw conviction solely on the basis of silence. So if silence is just a mere issue, if just a 10% of guilt, if it is, just give the direction. Even if after giving the direction, the jury hold that there is inferences that can be drawn, let them. Then you're secure. Okay, so give the koan direction. That's the test laid down, or the guideline rather laid down in Condron. But there is a precondition we have studied before. So this condition must be satisfied before drawing of an inference. What is that? The prosecution must have established a case to answer. When the judge fails to direct the jury on the precondition, either on terms of the standard direction or in similar terms, as in R versus Burchell, there is a clear risk of injustice. I'm explaining this. Look, if the prosecution theory was not strong, i.e., that is, the prosecution was not being able to establish a prima facie case to answer or establish a sufficient case to answer, defendant is not expected to answer, right? And if you, in that case, do not give koan direction, what might be the risk? The juries might think, even though the prosecution has not established the case, why is this defendant staying silent? He's staying silent because there is no answer. Because juries have not studied the law. They do not understand the defense psychology or psychology of a criminal, which says that they are entitled to silence at any stage, because when you are being charged or arrested, you go through physical or mental distress where you suffer and you do not want to answer in any case, because you are always alert as to what you might be saying, which might jeopardize your case. Therefore, defendants genuinely, and in most of the cases always, it is their trend to remain silent. And the juries, the normal people, they might think, okay, he's staying silent because he has done something, right? So koan direction could significantly eliminate the chance of the jury thinking that he has done it and therefore he's silent. Why? Because koan is kind of like a detailed guideline. You say about the burden of proof, about defendant's right to remain silent, about his defense against or privilege against self-incrimination, and the case to answer bit. You say everything in koan direction. Koan direction is basically a summary of what a good practice is when it comes to drawing of adverse inferences from silence. And therefore, koan direction can genuinely make a conviction safe and secure. So if you do not give similar kind of direction, such as in Cohen and Birchall, just have a homework and check what Birchall says, then there is a clear risk of injustice, and the juries might think that, look, this guy is not answering because he does not have an answer. We are almost reaching the end of the class, and I would be just now summarizing everything that we have studied today. Okay, so if you have joined late in the online lecture, here is your chance to recap. We'll go into the slide. That's a better option rather than seeing my horrid face. Just covered also my hair as usual. Right. Yeah. Oops. Good. So we were studying silence. The chapter is divided into two parts. When can the defendant stay silent, and when can inferences be drawn if he stays silent? Can he stay silent? Yes. At how many places? 3 places generally, or he has 3 rights. He would not answer police questions, number 1. He would not answer court questions, number 2. And the third right is the fact that even if he stays silent, it's his business, and court shouldn't intervene and start making adverse inferences from his silence. Who said it famously? Lord Mustard. What did he say? It's his own business, and no one should bother in his own business. He chose to stay silent because he wanted to, and no one should question his integrity as a result of his choice or business. There are 2 general presumptions. One is the presumption of innocence. The other is the privilege against self-incrimination, both of which allow a defendant to stay silent. So the general rule, is it subject to exceptions? How many exceptions? 2. Common law exceptions and statutory exception. What is the statute? Criminal Justice and Public Order Act, CJPOA. And what is the common law exception? R and parts. So last class, we have finished common law exception of R versus parts. We have looked at section 34 of CJPOA, which is the drawing of adverse inferences outside court. And we have also looked at a series of cases which explain what section 34 is. In today's class, what we focused on was section 35. Give me a moment. Let me just change the slide. Right. In today's class, we have focused on section 35 rather. Section 35 says when you can draw inference at the trial. Okay? You can draw inference at the trial when defendant is refusing to get sworn. So he is not taking the sworn evidence, right? And or when he's sworn, in spite of the fact that he's sworn, is now trying to refuse to answer particular questions. At what stage? At the trial stage. And before the activation of section 35, there should be a caution. What is the caution? The judges would say, look, we have reached a very late stage in the proceedings. You are at the final stage. This is the trial where conviction will be decided. If you have genuinely something to say, this is where you must say. And if you do not say, we are entitled to draw any inferences as appear proper from our senses. Okay? But before section 35 applies, there are some special categories where section 35 would never apply. Where if section 35 applies, are you allowed to draw inferences? Yes. If section 35 do not apply, you are not allowed to draw inferences unless the R versus parts common law exception apply. So here are cases where section 35 do not apply, which means if the defendant stays silent, you cannot draw inferences. What are the situations? Situation number 1, when the defendant is under the age of 14, you cannot expect him to answer. He's a minor. And when defendant's guilt is in issue, we've explained this in details. These are like the pre-trial stages or the management hearing, where you're actually not deciding defendant's guilt, but you're rather managing the cases overall. Okay. The most important exception to the application of section 35 is where defendant is suffering from any physical or mental illness, but that is coupled with another test, that physical or mental illness must make it undesirable for him to give evidence. We looked at common law exceptions or common law rules regarding to the mental condition. First rule is that Kavanagh says it's a very narrow approach that the court adopts. So just because you're mentally ill does not mean you can stay silent. Okay? Is it good rule? Yes, because it has been reconfirmed in 2009 by R versus Enzo. The court's overall attitude is, look, this is trial, this is where you answer. If you do not answer here, we cannot help you anymore, right? So they're trying to reduce the scope for defendants who are trying to escape from the application of Section 35, okay? Minor distress cannot be a mental condition, okay? And when deciding what sort of mental condition should you be having, there is a test of proportionality. What is the test? The more important a question, the more important an answer, and the more important an evidence, the stronger or the weaker should be your mental condition rather. So you must be suffering really badly in order to not answer, because the question that was being asked to you was very important question, okay? And if you're trying to stay silent on that, prove us that you are really mentally or physically ill. It is not enough to be just mentally or physically ill. The mental or physical illness must make it undesirable for him to testify. When does it do so? When your physical or mental health would be adversely affected, such as a defendant who is very weak in heart, who has gone through 3 or 4 bypass surgeries, and therefore if he is exposed to cross-examination, there's a very strong chance or risk that he might be adversely affected, or he might be having another heart attack, okay? At that time, he's not expected to answer. He falls within one of the exceptional categories of Section 35 of CJPOA. Okay, you can also not answer when you have a good cause. What is a good cause? A legal professional privilege could be a good cause. What is that? So what you communicated with your lawyer, what your lawyer said to you, you're not entitled, or you're not expected rather to answer it to the court. Okay, so court cannot ask you, what did you say to your lawyer last night? That is a area where I have a good cause to stay silent. Finally, we say that even if Section 35 applies, judge still can prevent the drawing of an inference, and they would rather do it in exceptional situation. In any case, the judges should always make a what direction? Koan direction. Koan direction has 5 levels. It says, firstly, burden is on the prosecution. Defendant can stay silent. Secondly, defendant has a common law right to remain silent. Therefore, silence is allowed. Finally, silence cannot be the sole basis of the conviction of the defendant. And the prosecution must have what? Established a prima facie case. So there must have been sufficient evidences adduced in the trial, as a result of which there grew an expectation on the defendant that he would be answering. Why? Because prosecution has already proved his case, not beyond reasonable doubt, but at a prima facie stage, which is adducement of sufficient evidence. So if there is sufficient evidence which is suggesting that the defendant really did it, at that stage there is an expectation on the defendant to answer. And finally, in a situation where the jury concludes, look, defendant is not answering because he has no answer, or that he has some answers, but those answers, if cross-examined seriously, they would be not surviving. Therefore, he's trying to keep mum. Therefore, he's trying to keep low, because the more he answers, the more his weakness in the case would be exposed. At that stage, you can draw inference. What did Condron say? Condron says something very important. What is that? It said, if the prosecution has convinced the jury that an inference should be drawn, and if it is one of the situation where a Koan direction and virtual direction is not given, there is a high risk. There is a high risk what? That Article 6 might be violated. Why? Article 6 says right to fair trial, and adherence to strict rules of evidence and judicial direction to jury is one of the fundamental elements of the right to fair trial. And if you are not adhering to judicial direction and evidential rules strictly, you're jeopardizing defendant's right to fair trial. You are making the conviction unsafe, and therefore there's a high risk and high chance that the upper court might quash the conviction. So a trial takes months to finish, and it takes lots of expenses to finish. So even if you are satisfying conditions of section 35, is always a safe practice to give the co-on direction, because non-giving of the co-on direction might inject the thought that some article of ECHR, most importantly Article 6 of ECHR, right to fair trial, has been breached. Okay, so we have just left section 36 and section 37, which would just take half an hour to finish, but I cannot finish it today. Today's class ends here. Probably, are there any questions that I could answer? I see there are 8 viewers. Do they even know how to ask that question?
Yes, they do.
Any questions, sirs? I take 30 seconds to allow you to ask question. Otherwise, adios. Okay, so I take a leave. Thank you for attending the class, and we just have section 36 and section 37 of the CJPO left. Revise. I'm leaving these notes on the photocopy section. Collect them at. I'll try to make the soft copies available on the page as well, but try to collect them from the photocopy section and try to take the notes from those who've done the classes. Thank you very much. Bye.